submission column via goals later on. It's just to let you know that these are the written assignment topics that you may undertake from now on. Yeah, you can start doing your research. You don't have to wait until I come to the relevant topic, like the topic on general conduct. Just do your research and start collect the materials and do your write-up. Okay, so 4 separate submissions for each for this one. Yeah. So any question before I move on?
No.
No question? Okay.
No.
So next, yes.
No.
Anybody would like to speak, please unmute and voice out your concern if any. Ada lagi soalan? Okay. I will go on to the next task. Okay. This one is an infographic poster assignment, and I will only require 2 submissions from each KLB. And this one you can actually prepare the infographic poster after we have our engagement with an invited practitioner that I think I've informed you.
No, doctor.
Yeah. So the invited practitioner is actually a friend of mine, and she has agreed to do a live engagement with all of you on ethics on fees, trust money, and solicitors account. Okay. So this one tentatively is on. Let me check again. 29th, on the 29th, which is on Monday. So please provide the suitable time for the meeting with the practitioner. Okay. And I need somebody, if possible, to administer Zoom, right? Because I believe Zoom would be a better platform, because you can see everybody, everyone's screen, and I think it's better for interaction between you all and the practitioner. Yeah. So the practitioner is Wan Jura and Co. Yeah. So the apps that you can consider using are Prezi, Canva, so you can choose which apps that can help you come up with this infographic poster. So based on what you have read, the materials you have read, and also the input that you will have gotten from the lecture given by Madam Wan Jura. Yeah? So this one is only one submission from each KLB, and we might just have the poster presented by each KLB later after we have the engagement with the invited guests. Yeah. Any question? Can you hear? Is it clear
Doctor.
on your end? Yes.
So, meaning to say that this infographic assignment will be probably on July, is it? Because you said that the talk is on 29th of June.
Yeah, probably the first week of July.
Okay, alright, sure.
Yeah.
And only each KLB, right?
KLB, not T, yeah? K, just
Okay.
2 submissions.
KLB.
KLB 1, KLB 2. I'm going to discuss live, like what we are doing now.
Okay, so the gist of the content, alright, so the gist of the poster will be based on what Madam Jura's going to
Yeah,
deliver.
together with your own reading. So You have to combine your own research and also the input from the practitioner. Yeah.
Okay.
Okay. So the next is case review. This one is I give the same, I think same question for all TLB. So we will have 8 submissions. Yeah. So the deadline for this one is 15 July. So if you know notice, I will try to shift everything before end of July. I will try to make the submissions open before you know the end of July, so you will have ample time to do your revision. Okay. So this one is a case review assignment. Just 102,000 word limit. It's about 2 to 4 page length. And just pick a recent case, decided case on the topic of professional misconduct and disciplinary proceedings. All right. This one can be an appeal case. Normally, professional disciplinary proceeding, you have a tribunal, uh, you know, uh, providing its decision, and the decision can go to court if it is appealed by the, by the concerned lawyer who face the proceeding itself. Okay, so you may find recent cases. Make sure each DLB picks a different case, right? Do not discuss the same case. Yeah. So the order of the review is as usual. You have the case citation, the facts, the judgment, the main principles, and the short commentary. Okay, your own review of the decided case. Yeah. So this one, I also intend to invite a practitioner to share his or her experience in conducting in participating or involving himself in any disciplinary proceeding. Okay, I have got one contact person, but I have not reached out to this lawyer. Okay, so I think he's the president of the State Bar of Kedah. I have not reached out to him, but whatever it is, I will update you later, and we might have if he agrees to sharing session, having a sharing session, we might have this one in July. Yeah, maybe second week of July. Right, you may prepare the case before the talk because it is not confirmed yet. Yeah, you may prepare the task before the talk. Right, and the last is a video presentation. This one is just one submission from each KLP saja, macam yang infografik tadi ya. So this one is on the topic of ethics in publicizing the profession. I think this one is not a really heavy topic. Okay, it's about how the profession lays out rules on ethics of publicizing your service, okay, your firm, etc. So this one, a lot of the rules can be found from LPA and some of the rules on publication of the publicizing the profession. So just prepare a video uh, that contain the rules, ethical rules, principles, and practices on advertisement and publications, prohibition on touting, and letterheads, etc., and free legal advice. Right? These are some of the content on which you can prepare your presentation, video presentation. So it's just a short video. The duration is about 50 minutes. Okay. Just make sure it is attractive with text and voice to illustrate the content. Just make sure that it is not too kiddie or childish. Make sure it's a bit professional, okay, in terms of the video content, because you might want to present this to, for instance, LPQB if they come for a visit and if they want to see, the lesson materials, and if you your video is very informal, then I don't think it's quite appropriate. Make it a bit professional, yeah. So we will set a date for you to play the video, and I'll give the proper marks. Okay. I think that's about it. Um, I think you will have enough time to do all this, because uh, they are group work, not individual tasks. So make sure you um, distribute the work fairly among all group members. So make sure everybody contributes. Okay. If you have issues, you come to me. If anybody has any issue of getting contribution from any group member, just inform me and I'll do proper investigation. Okay. Any question?
Madam,
Yeah.
it says here that the video must contain combination of attractive graphics, text, and voice to illustrate the content. Text here means subtitle or just brief slide in the video?
Text means like provisions that you quote from the relevant rules or the LPA itself. So I'm more interested in the substance rather than the rest, because we don't need subtitle if you speak in English. Make sure the voice is can be heard clearly. What I'm more interested is to see which rules you refer to when you, for instance, talk about advertisement or prohibition on touting. If you have any case law, please also talk about it in the video. Just put the case name and then summarize a little bit on the case. Yeah. Is that clear? Jelas ke? Ada soalan lagi?
Yes, madam. Thank you.
Okay. So I will upload the task that we just discussed onto Microsoft Teams later. I will also share with your representative. Okay, for today, I intend to proceed with topic 4 on privileges. Yeah. Give me a minute for me to share the slides with you. May I know how the number of students who are with us right now? Can you check? Because we have 2 KLBs, right?
Currently we got 95, doctor.
95. That means almost everyone is already in the session. Okay. All right.
Yes, doctor.
Can you see the slides? The first slide here. Boleh nampak?
Yes, doctor.
Slide.
Privilege of advocate and solicitor.
All right, thank you. Then this is the topic for today. If you have your LPA, please bring it and refer it. Yeah, have it by your side lah.
Yes, madam, you can see it.
Okay, some common types of work an advocate and solicitors conduct or execute include representing their clients, okay, in litigation, preparing affidavits or sworn statement. Interlocutory proceedings are proceedings, in the middle of your trial. You may have some applications to make to the judge, like for adjournment, okay. Interlocutory proceedings must relate to the rights of the parties, yeah. So other than other than this, you have, defending actions in criminal trials and also conveyancing related work such as drafting loan, corporate documentation, etc. You also have ADR within your scope of work, which is alternative dispute resolution, right? And as you know, the practice is governed by LPA. Yeah. So the URL that I put there is actually good if you can go through the website. It's actually the website that I displayed just now. It has a good overview of the pre-trial and the trial processes in in a very concise manner of description. You can get a glimpse of what lawyers actually do and what the processes mean. Okay, so please have a look. Just later, after this, go to the website. Yeah. So when you talk about privileges of advocates and solicitors, we will look at section 35 through to 40, and there are some other sections which I will also review with you later. Okay. If you can open up your LPA and refer to section 35 that talks about the exclusive right to appear and plead in all courts of justice. All right. Are you referring to your LPA now? Yes, Doctor.
Yes.
If you can read subsection 1, yeah. Any advocate and solicitor, okay, have the exclusive right to appear and plead in all courts of justice in Malaysia, and as between themselves shall have the same rights and privileges without differentiation. Right? So who do we mean by any advocate and solicitor? So you have to be careful to know exactly who can actually appear and plead in all courts of justice. And what is the meaning of courts of justice? Okay, does it also include Sharia court? Does it also include, in tribunals like small claim tribunal? What do we mean by courts of justice? Yeah. So section 36 says that no authorized person shall practice or do any act as an advocate and solicitor unless his or her name is on the roll and he has enforced a valid practicing certificate. So these are the two qualifications for you to appear and plead in all courts. Okay, when we mention all courts in Malaysia, they exclude Sharia courts and other small claim tribunals, penghulu court. We mean by the the main courts, from magistrate up to the federal courts in this context. Have you all looked at the meaning of a qualified person? How is it different from an authorized person? Can anybody, share your thoughts on this? What's the difference between a qualified person and an authorized person? Any idea? Okay, saya boleh panggil nama. LB1.
Doctor,
Yes.
in my opinion, authorized Hello.
Yes, we hear.
Authorized person may be someone that has legal power to enforce certain action, um, and qualified person may be someone that has an expertise in that particular field, but not doesn't have the power to enforce certain actions. That for my personal understanding.
Okay. Remember when you have your act before you. Remember when it comes to the question on meaning and definition, always refer to the section concerning the meaning and definition, right? So dekat depan, okay, you ada definition of advocate and solicitor under section 3 interpretation, ya. Ada tak you jumpa qualified person and authorized person?
Ada qualified person.
Madam.
Okay. Siapa-siapa boleh explain the meaning of a qualified person in short? Okay, the person who has passed the final exam leading to the degree. So you have to have the required bachelor degree, or you can and also you can be a barrister at law. You can be admitted as a qualified person, okay, or is in possession of such other qualifications as may be notified in the Gazette. Ya. Gazette ni adalah dikeluarkan dipublish or declared by the board LPQB, ya, to make you as a qualified person. Okay, it doesn't mean that the meaning of qualified person is exactly the same as the meaning of an authorized person. I don't see any specific interpretation of the word of the phrase authorized person. Kalau jumpa beritahu dekat section 3. Tapi you have section 36 to further give you some clue of who an authorized person is. But in order for you to be a qualified person, you have the specific requirements, okay, seperti yang kita tengok tadi, okay. But doesn't mean that a qualified person can appear and plead in a court of law. So in order for you to plead and appear in a court of law, you have to be an authorized person. So kalau you tengok section 36, okay, no person shall practice as an advocate and solicitor or do any act as an advocate and solicitor unless his name is on the roll, okay, and he has a valid practicing certificate authorizing him to do the act. So this is what I think this is a part that captures who an authorized person is, okay. So a person who is not so qualified in this act, qualified in the sense of to appear and plead, then he is an authorized person. You may already be a qualified person, but if your name is not on the roll, you do not, or maybe your practicing certificate has expired. It's no longer valid. You need to renew every year. Yeah, your name may be struck off if you have, for instance, committed a crime or you have been convicted of a crime, or maybe other serious disciplinary offense. You may be struck off the roll ataupun for other reasons. So you're not allowed to appear and plead, right? Macam saya, I've been admitted, I'm a qualified person, but I don't have a valid practicing certificate because I'm not allowed to have it unless I give up my teaching. Yeah, it doesn't actually tolerate dual profession. Okay, advocate and solicitor needs to be an advocate and solicitor without having other professions alongside. Yeah, so I am a qualified person. I've been admitted, but I don't have this practicing certificate, right? So I can't appear, right? I will try to show you. Hold on a second to, just to share with you some of the certificates of practice that you might be interested to have a look. Mana tadi? Sekejap. Okay, dekat sini. Alright. Mula-mula sekali saya tunjukkan alright. This is the first stage where you got admitted. Okay. This is a perintah diterima sebagai sebagai seorang peguam bela dan peguam cara. Nampak ya contoh ni? Boleh nampak ke? Saya punya my good friend shared with me, dia punya. Okay. Boleh nampak ke? Boleh.
Nampak betul.
Selepas you complete you punya chambering, alright, bila dah cukup masa untuk apply for admission, you ada banyak documentation untuk you file. Di akhir proses, okay, you akan dapat satu perintah untuk diterima dan didaftar, okay, didaftaraikan sebagai seorang peguam bela dan peguam cara. So daftarai ni adalah dia punya register yang is maintained by the acting registrar of the High Court of Malaya. Okay. So ini adalah first step. Lepas tu bila you nak practice, you kena apply sijil untuk beramal. So macam this lady ada sijil untuk practice. So it is an not only qualified but also authorized person to plead, to appear and plead in courts of law. Right? Ini adalah contoh ya. You ada also sijil annual. Nanti you tengok dalam LPA, you kena ada sijil annual, annual certificate ya, issued by the Bar Council to just confirm that you have complied with the provisions of Section 32. Okay, Section 32 on issue of sijil annual. Alright. So just to have the certification and approval from the bar that you have no or they have no objection towards you to continue practicing, alright? And then you are exempted from accountant's report and not in arrears, tak ada hutang, okay, berkenaan dengan compensation fund and intend to practice. So ini adalah antara certification that you have to renew annually, you have to obtain annually in order to continue to be an authorized person, right? So ini adalah antara dokumen-dokumen yang you akan jumpa nanti bila you nak apply to be admitted and to practice, okay? So we go back to the slides. Jika seseorang adalah, is someone who is unauthorized and he tries to, act as an authorized advocate and solicitor by appearing in court on behalf of anybody, then it is actually it's a criminal offence. There are criminal penalties spelled out under Section 37. Right? You can look at Section 37 to know what the penalties are. Okay. the person shall be guilty of an offence and shall, on conviction, be liable to a fine not more than 2,500 ringgit or to imprisonment for a term not exceeding 6 months or both. Okay. So are you with me so far?
Yes, madam.
Yes.
Yes, doctor.
Okay.
Yes.
Alright, so section 36 is very important. It is a vehicle used by Malaysian Bar to actually limit or put a limit on any unauthorized person from practicing as an advocate and solicitor. So this is a gatekeeper lah, yeah. In the case of Joseph Au Kong Wang, okay, there was an action by the Pahang Bar to restrain and authorize an unauthorized person to practice. However, the application did not succeed because of the issue of local standard. So supposedly it was the Malaysian bar who had the local standard and not the state bar. Okay. So you have to be incorporated. So the LPA itself, is the source for the legal existence of the Malaysian bar. So in order for you to bring an action, you have to have a legal standing. Yeah? So the issue comes down to the fact that Pahang Bar, State Bar, does not have the locus to bring the action. Yeah? So as I mentioned, an authorized person must have both a valid practicing certificate and also his or her name must also be on the roll. Okay. You can look at section 28 and 29. It is a registrar of the High Court that keeps the roll, okay, with the dates of the respective admission of the A and S, and also the keperluan, yeah, the need to make a declaration, yearly declaration of the prescribed matters to be issued a practicing certificate. And section 30 talks about disqualification for practicing certificate. Yeah. So boleh tengok the case of Lakshamani and Datuk Sami Velu, ya, on section 36, right? Mana tadi? So a person who has a valid practicing certificate has the exclusive right to appear and to plead. So this is confirmed in his laws, yeah. So next slide. We talked just now about the right of audience. To appear and to plead means to have the right of audience, to conduct proceedings in court. Okay. So there is another familiar term or phrase whereby only solicitor on the record has the right of audience, okay, on behalf of his client. That means the one that is retained by the client, okay, not just anybody, but the one that is on record or that has the contract of retention with the client, okay, to appear on behalf of the client, right? What about foreign lawyers? Can have the right of audience in any of the courts? Generally, they're not granted the rights of audience, but there is an exception in section 28A. If you can flip to page to section 28A. Okay. Ada tak? So Attorney General has a power to issue special admission certificate, yeah, provided the person satisfies the requirements in 28A, yeah. Kita tengok requirement B. He has been practicing as a barrister or a solicitor, blah blah blah. Okay. So this is within the power of the AG to admit, yeah. Section 18 the court may admit a foreign lawyer to serve as co-counsel if he was a citizen of or a permanent resident in Malaysia. Okay, so section 18 untuk kes di mana foreign lawyer is also a citizen or a PR and would be eligible, memenuhi criteria to be admitted. So kadang-kadang special qualifications or experience will give advantage to the foreign lawyer to be admitted. Those that our lawyers do not have expertise in, then chances are they can be admitted. Priority is given to those with special qualifications. Or maybe he has been instructed by an advocate and solicitor in Malaysia to act as a co-counsel, for instance. So we also have these rules, on licensing of international partnership and qualified foreign law firms and registration of foreign lawyers. You boleh tengok kalau you beli Legal Profession Act together with the rules, and it's I think the rules are somewhere in the book. So macam Zico I think they set up an international partnership where they have presence in other ASEAN countries as well, right? So you have to look at the rules in order to know. Right of audience of government legal officers. Okay, so they do not need to have valid certificate. Practicing certificate tidak diperlukan. Contohnya untuk officers of the Aegis Chambers, dia boleh appear in the court without being admitted. Okay, seperti saya dulu adalah peguam persekutuan, so that time I was not yet called to the bar, okay, but I could appear if I was instructed to. Okay, so this is an exception to being a qualified and authorized person. Okay, even police inspectors or environmental officers boleh juga appear, okay, provided they are sanctioned by the for instance public prosecutor. And also other officers as persons who can act as advocate and solicitors. This one you can see section 38. Okay, section 38. So ada dinyatakan di situ seperti officers of the Public Trust Corporation, Director General of Insolvency, right? They can have the right of audience if they're given the sanction, okay, to appear, okay. Siapa lagi, okay? Even any full-time member of the academic staff of a faculty of law acting solely in an advisory capacity upon instruction from a practicing advocate and solicitor. So yang ni saya tak pernah come across lagi, but it's one of the one of the listed persons who can also act as an advocate and solicitor. Tadi yang ni adalah berkaitan dengan international partnership tadi. We're not going to go in depth into this one. Pupils in chambers, sama ada student chambering boleh have the right of audience. Section 36(2)(a). Somebody can inform me what it is about? 36(2)(a). Yes. Siapa boleh share the content of 36(2)(a)?
Doctor.
Yeah.
So section 36 2A is about the pupil is permitted to appear on behalf of the master of the firm. So
Okay.
basically that's the gist for that section 36(2)(a).
So is it at any time during the privilege, or you have to appear within a certain time frame only? You are allowed to appear within a certain time frame only.
Within a certain time frame only, because based on section that 36(2)(a), during the period of 3 months from the date of the order.
Alright, so you have to make an order. Uh, in other words, the master of the pupil needs to make an order for his pupil to be permitted to appear. Alright. So within that 3 months time frame, you can appear if you are allowed to. Normally, to mention a case lah, yeah, to mention a case, to enter judgment in default, okay, straightforward court proceeding, yeah, or to apply for bail or to take a consent judgment, okay. And anybody from KLB2, inform the group, the other group, what a consent judgment is, because we discussed this one yesterday. Anybody from KLB2? What is a consent judgment? We talk about this in topic 3 on, yeah.
Consent judgment.
Consent judgment is judgment validating compromise between solicitors.
Okay, judgment that approve and endorses a compromise achieved or a settlement achieved between two parties lah, yeah. So you can actually apply for a consent judgment if both parties have reached a settlement out of court, okay, not to proceed with the litigation, okay. So in order to enforce the settlement out of court, you need an order from the court, yeah, and this one is called consent judgment. So people in chamber can apply for that one as well. So in Re-Bar Council, the court held that at the expiration of the said period, the pupil may appear to conduct the matter in chambers, okay, of the High Court, in chambers in the session or magistrate courts, or in the open court before any magistrate. So the highest court is High Court, right? So we come to the next element on in section 36, ya, selain daripada right of audience, section 35 and 36, okay, are relevant when we talk about privileges that advocates and solicitors are entitled to. Okay, so privileges adalah akin to rights to be exempted from legal actions, okay, for your conduct as an advocate and a solicitor. Okay. Privilege can be privilege from arrest, and you have from defamation, okay, and professional communications, which may also invite defamation. So from arrest, if you are attending a court matter, you are not subject to any civil arrest, okay. And this one also extends to not only advocate and solicitors, but also witnesses, parties to arbitrations, creditors of bankrupt. Yeah. For instance, a solicitor conducting a litigation is not required to pay if arrested for not paying costs. Okay, dia tidak membayar, for instance, kos yang diarahkan oleh mahkamah contohnya. So he may apply to the court at which he is attending supaya dia di discharge, okay, on the ground of privilege. Okay, so in order for you to apply this privilege, to have this privilege, you have to be attending a court matter. Okay, if you are not attending a court matter, this might not be available. Yeah, and from defamation, so this also applies when you conduct litigation. Yeah, you may apply your right to um, speech, and to speak out in defense of your clients, and to litigate on his behalf. Okay, in the process, you might inadvertently defame or insult the other party or other persons. So macam members of parliament juga ada privilege, ya. So an advocate and solicitor, okay, is free to speak out of malice, the most irrelevant words, provided it is made in the course of a judicial inquiry or before any court of justice. Sometimes you hear the arguments are very insulting. Words used can be very insulting, so they are protected actually so long as they are conducting a trial or in the process of litigation. This one is a quote from Honorable Lord Danning. By the way, thank you to Filza for sharing the article. I will put up the article on Teams later with other reading materials. I think it's on your course outline. If you have access to this article, please read this up. It contains a lot of insights from this very senior and respectable figure, Lord Danning, okay, on the subject of being the honest lawyer, okay. So accepting that the lawyer's function is to state his client's case as strongly as he can, the law grants him full freedom to exercise this function without fear. So this is a privilege that the law confers on the lawyer, okay. He is given the cloak of an absolute privilege. He may use the most abusive language about others. He may be actuated by malice and ill will, yet he cannot be made subject to a libel or defamation action. And this absolute privilege carries with it a special responsibility to see that it is not abused. Right? So be careful. We have actually discuss the thresholds and limits in carrying out your duty as an advocate and solicitor. If you cross over the line, okay, there are consequences such as contempt and others if it interferes with the sanctity of the judicial institution, reputation of the judge, etc. You might find yourself in trouble, but basically you are protected, right? Professional communications. So you as an advocate and solicitor, it is inevitable that you have verbal and written communications with your client. You take instructions from them. You also give legal advice to your clients, okay? So to what extent our communications between solicitors and clients are privileged and protected? Okay? So in general, they are protected, okay, and they are inadmissible in evidence. Okay, so this is known as legal professional privilege. Okay, legal advice privilege, in other words. Yeah. And it also extends to communication which have the purpose of seeking or giving legal advice, okay, between a solicitor and the client, and between a solicitor and third parties, as well as the client and third parties. So it goes beyond the mere ambit of client and lawyer. It also involves third parties, okay, and provided they are made for the purpose of contemplated legal proceedings. So it involves, a contemplated legal proceedings. So communications with third parties may also be privileged, okay, may not be admissible in evidence. Right? So what is the rationale for this privilege? It is actually to ensure a fair trial, all right, so that you can actually act in the best interest uh, of your client, give the best advice, okay, without being exposed to suits and other threats. Yeah. Professional communications. Generally, the law is that no advocate shall, without his client's consent, disclose any communication, okay, contents and conditions of any document, and any advice. So these are the three scopes in which privilege extends to, right? Not only communication, but also content, written content and conditions in any document, in the course that they have come to be acquainted in the course and for the purpose of their retention or employment, and advice to the client. So is this a lawyer's privilege or a client's privilege actually? Okay, if you look at case laws, the source of this privilege is much to be, reduced from case law. Yeah? So it is equally well established that the privilege is that of the client. Okay, so it's the client that has the privilege as opposed to the legal advisor or the ANS, right? So what does this mean? Okay, so if you can look at the quoted portion of Lord Buckmaster's here, the right to have such communication so protected is the right of the client only. It is a privilege in the sense that it is the privilege of the client. If the client chooses, okay, this is important, if the client chooses to withdraw the veil, that means if the client chooses to set aside the privilege or to not apply it, then the law interposes no further difficulty. The communications then are then available as evidence. Okay, so it is an option that is given to the client, or the right that is given to the client rather than the lawyer himself. But the lawyer is strictly prohibited from disclosing communications regardless of what he feels, okay, his personal feelings in the matter. Okay, he may have an adverse feelings, okay, on an issue pertaining to the client's case. All right, he may think that the client is guilty, for instance, but he must not reveal any part of the communication and content or document. Yeah? And this strictness sometimes can put lawyers in a difficult position, such as in the case of Gideon Tan and Teh Poyi, 2017. A Malaysian solicitor was not even allowed to adduce privileged communication in his own defense against a committed proceeding. So it is quite strict, yeah, in the sense that you are not allowed to reveal any part of the communication, even for the purpose of defending yourself against the committed proceeding. So any question before I proceed with the Evidence Act, which has bearing on our discussion on privilege? Any question?
Madam,
Yeah.
you mentioned earlier in the slide there is a privilege from defamation. Is this privilege absolute or does it has its limit?
I think it has its limits ya. Nanti kita akan tengok selepas ni apa dia limitationsnya ya. So let's go first to section 1 to 6.
Thank you, madam.
So professional communications are also governed in terms of their privilege, okay, by section 1 to 6, whereby this one is under Evidence Act, yeah, that no advocate shall at any time be permitted, unless with the client's consent, to disclose any communication in the course or for the purpose of his employment, or to state the contents of or conditions of any document, or to disclose any advice. Macam yang kita lihat tadi, 3 konteks, ya. Ini sebenarnya di bawah section 1 to 6 Evidence Act. So next question is the one that your friend asked just now. Is the privilege absolute? Can there be exceptions? Right? So does the privilege under section 1 to 6 Evidence Act solely apply to a qualified advocate and solicitor, or does it also extend to an in-house legal advisor? For instance, whether communications within a bank officer and an in-house counsel can be privileged as well. In the Malaysian context of practice, based on my reading, this is also protected. Yeah, in-house legal advisors communication with other parties are also privileged. Okay, what are some of the exceptions? Right, you can find this under provisos A and B under section 1 to 6 of the Evidence Act. Right, so under A is on communication made in furtherance of any illegal purpose. Right, and B, any fact observed by any advocate as showing that any crime or fraud has been committed since the commencement of his employment. So if he or she has come across any fact that reveals the commission of any crime or fraud, then such communication can be can be exempted from the privilege. It can be admitted as an evidence in the court of law. Sama juga if there is any communication that is made to further any criminal intention or illegal purpose, then that would not be protected by the law. Yeah. It is immaterial whether the attention of the advocate was or wasn't directed to the fact by or on behalf of his client. Okay, so it is regardless of whether he has his knowledge has been informed by the client or not with regards to A and B, as long as it's like strict liability juga lah if it's a communication that is in furtherance with the purpose of having an illegal motive. All right, so that might not be protected. Yeah. Section 1 to 9, confidential communication with legal advisors. Right. Section 1 to 9 of the same Act, meaning of the Evidence Act. Yeah. No one shall be compelled to disclose to the court any confidential communication which has taken place between him and his legal professional advisor unless he offers himself as a witness, kecuali dia sendiri menjadi seorang saksi. Alright, so in which case if he offers himself as a witness, he can be compelled to disclose any such communication if it is necessary to be known to explain any evidence, right? So this one is a communication with legal advisors. So you have to read section 1 to 6 with 1 to 8 and 1 to 9 of the Evidence Act. Okay, as I mentioned just now, this is rather a client's privilege, so the client has a liberty to waive the privilege. Okay, and the waiver, be careful, it can be expressed or it can be implied, inadvertent, right? By coincidence, for instance, by conduct. So the clients have to be careful that they do not inadvertently waive the privilege by voluntarily, for instance, delivering a privileged document to a third party without imposing any obligations of confidentiality. So normally, if it's PNC, you have to mention on the document that this is PNC. Okay, without having that on the document, it may be a public document and you can be regarded as already having waived your privilege, right? The privilege of the communication or document. And the privilege may also be abrogated by a clearly worded statute. Okay, for instance, under the anti-money laundering, anti-terrorism, and financing and proceeds of unlawful activities, this is AMLA. A High Court judge may, in an investigation, override advice privilege and order an advocate to disclose information in respect of a transaction relating to property liable to seizure under the Act. So, jika ia berkaitan dengan prosiding di bawah mana-mana akta dan di bawah akta tersebut, there is a clearly worded provision which actually abrogates the privilege, then the privilege is not effective. But the intent to abrogate it must be clear from the statute. Okay, in Bar Council and Ketua Pengarah LHDN 2018 case, the High Court held that the general provisions of Section 142 Clause 5 of the Income Tax Act did not actually override or supersede the specific provisions of Section 126. Maksudnya tidak semestinya dalam semua keadaan, okay, the intent to abrogate is clear cut. So it depends on how the court interprets it. Okay, in this case, the court says that it is not enough to abrogate the privilege. Okay. So the court held that the Inland Revenue Board, lembaga hasil, therefore, could not use the Income Tax Act as an instrument to raid law firms under the pretext to fish or to search for information on the clients of the law firms. Yeah. So ini adalah salah satu case law berkaitan dengan perception tadi. In the 2006 case, Datuk Anthony C. Teo Guan, alright. Okay, the questions that arise include: does the Malaysian evidence law, okay, extend protection to all communications or to just confidential communication? This one will actually better explain what we have just discussed in the previous slides. So we can support what I just actually elaborated. Can a client implicitly by conduct waive legal advice? And assuming a communication between a solicitor and his client is privileged, would the exhibiting of that communication in court documents, okay, tantamount to a waiver? Bila you incidentally or with intention exhibit the privileged document in a court proceeding, would that tantamount to a waiver that you have set aside your privilege? Okay. So take a look at the facts in this case. The defendant was an executive director of a company. Okay, he was asked to provide a legal opinion, all right, to certain allegations made against the plaintiff, all right, with regards to the operation of the company. All right, so the defendant in this case, the executive director had instructed the solicitor appointed, okay, but actually he was appointed without the benefit of any resolution. Normally, if in a case of a company, you need a resolution by the board of directors as to whom which firm will be appointed, which advocate and solicitor. This one was without. So the defendant later testified that it was clear that the legal opinion would be circulated to the directors, a number of directors of the company. So he knew that the legal opinion would be, would be shared with the other directors. And she believed that the lawyer in this case was a she. She was instructed by the defendant in his capacity as the director of the company. Okay, the defendant being the director. So the written, in this case, the written legal opinion, the problem was that it was not marked private and confidential. It was faxed to the defendant and later circulated to a number of people. Some of them are directors of the company and others include members of the audit committee